We have a lot of new members today, so really excited to have you all. And I do want to pick on those who have been here before. Can you stick up your hand if you've been to the Worksite Wellness Network event before? Look at how many new members we have. I mean, you guys are great. Look at how many new members we have. That's really exciting. Well, welcome. Thank you guys all for being here today. We have lots of information to cover. We have Allison Jacobsen with us from Barran Liebman. Iris got pulled away at the last minute, so we were hoping we could have a little tag team, but Allison is ready to carry this information. To give you guys a little bit of background on us, the Worksite Wellness Network's mission is to connect, learn, and share. So everyone who didn't stick up their hand, there was a lot of you. Those of you who did, make sure that you're welcoming the new members, make sure that you're saying hello and making everyone feel just super welcome and a part of the group. That's really the mission here. We want to help to connect you all as your own internal peer network. So if you guys hear stories, feel free to connect with each other afterwards on LinkedIn, say hello. You don't have to only be learning about Worksite Wellness at this event. You can be connecting on your own and grabbing coffee and hanging out and chatting together too. Okay, so some background. The Worksite Wellness Network was started originally by my wonderful husband over there, Benjamin, and Renee Coombs. And I'm going to step away from the podium just for a second. Renee is not with SAFE anymore. She's not in the Worksite Wellness realm anymore. But because this is the first event that we don't have her, I wanted to do a quick little selfie with everybody and show her who's all here. So, but I left my phone over here. Okay. I'm not a selfie girl, but we're gonna try and do this anyway. Okay. And we're gonna film. All right, everybody ready? Big smiles. Okay, I think I got you all. Thank you. So we were started in 2012. And really the mission is to support those that are managing their own internal wellness programs. This event is a spin-off of the Worksite Wellness Summit, and we would see a lot of groups coming to the summit and learning a lot of great information and not necessarily having the time or support to be implementing any of those activities and any of the information throughout the year. So you guys are a support group for each other for Worksite Wellness. So just remember that, and if someone calls you in the middle of the night and they're having a hard moment with wellness, just be there for them, okay? Okay, so thank you so much to the Partners Group for having this event space today. They brought us all here together and were able to provide us a location to meet. I don't know that this will be our permanent home throughout the year. It might be, it might not be. Committee's still chatting about what that looks like. So make sure that you're checking your events. Make sure you're checking your event invites for the locations, because if it's not at this location next time, we don't want you to be here by yourself waiting for everyone else to show up. We have 5 meetings a year. We usually take a little bit of a break through the holiday season and through Q4 open enrollment, just because it gets a little bit crazy, but then we'll jump back when you guys have a little bit more time. And for a little bit of a breakdown so that you guys know who's in the room with you, these have been our stats throughout the last few years. So we've got 70% of members are employers. So I hope you guys had a chance to write your company names on your name badges. If you didn't, feel free to grab a marker and add that in there. But just so that you know where each other is from, if you guys want to connect afterwards. We also have about 10% are nonprofits. So that could be OHSU, that could be schools, that could be a lot of different locations. We also have 10% are health plans. So a lot of them are...
This is the Wi-Fi information. So
oh.
Sorry.
I have Wi-Fi information for just a second later. Health plans, so a lot of them are kind of seasoned vets in wellness as well, so if you have questions, feel free to ask them. And then 10% are service providers or vendors. And then the little gray guy, we have less than 2% are other. So wherever you came from, welcome. Okay, this is our current committee. I am so excited for this group of people that meets and is just putting their heads together. Every time we meet, we come up with a list of ideas for new topics for the events, and then we're gonna whittle them down and we come up with another 10 topics for another few events. So you guys are gonna probably start getting a lot of information outside of the events, some videos, some blogging, some more information, just kind of content pushed towards you. But this is our group. So if you guys can all stand up if you're here, please. We've got up in the front Alexa from Partners Group, Benjamin from Catalyst. You guys can give him a round of applause, sure. We've got Chase from Cigna, Cassie Buckroyd from Columbia Sportswear. We've got Emily from Cambia, Carmen from Cascade Centers, and pictured but not yet present, Emily Riviere from Mutual of Omaha. And I think that's the only one. Oh, and me. Hi, I'm Kerwin. I'm from Catalyst too. Okay. And the moment you've all been waiting for. We've got Allison Jacobsen here from Barran Liebman. All right.
Thank you, Allison.
Thank you so much for having me. I'm so sorry that Iris Tilley could not join us today. We were going to do a little team presentation, but she did get pulled away at the last minute, so I am here. Sorry for all of those who paid big money to be here to see Iris. Sorry, I hope I don't disappoint too much. Okay, let's see. All right, there we go. And just as a warning, my presentation, my slides are not nearly as exciting as the ones you just saw. But you know, we're lawyers, so we don't do anything fancy like that.
Pretty slides.
No pretty slides. We have billable hours to do. Okay, so it sounds like a few of you have been at WWN events before, so you may have heard this spiel before, but just to give you an idea of what we're talking about today, I wanted to give you just sort of a basic legal landscape of wellness programs and how they fit into the various legal requirements and considerations. I know that there have been a lot of questions recently. There is a development in the wellness world. There's case law out there, or an ongoing case that may change this legal landscape, and I'll get to that at the end, but I wanted to give you a little bit of background information first. So I'll give you that legal landscape, and then we'll talk about wellness program design today, the different types, and how your wellness programs at your workplaces might fit into those. And then at the end, like I said, we'll talk about what's going on at the EEOC now and what's going on with a case called the AARP versus the EEOC, and what that may mean for you in the future. So let's get oriented with the legal landscape here. So wellness programs, and again, sorry in advance if a lot of this is information that you've already heard, but it's always a good refresher. But if you do have questions throughout, let me know, or we can take questions at the end as well. So wellness programs are regulated by a multitude or multiple bodies of rules. So when we look at these different bodies of law, almost always HIPAA is going to come into play. Sometimes the ADA, or the Americans with Disabilities Act, is going to come into play, and I'll go more into that in a minute. Sometimes GINA, or the Genetic Information Non-Discrimination Act, comes into play, and then you always have those pesky tax rules and state and federal non-discrimination rules that are always lurking in the background. So what can be tricky about designing and implementing, as you know, employer wellness programs, is that compliance can be somewhat difficult because you're not dealing with one set of rules. You're dealing with multiple, or possibly multiple sets of rules. So you have to make sure that just because you're in compliance with one set of rules doesn't necessarily mean that you're in compliance with the other. So I wanted to give you an overview of the final ADA regulations that came out last year, or came into effect at the beginning of last year. So I believe that Iris gave a legal update seminar, I think it was October of 2016. So that was a few months before these new rules came into play. So I know at that time that there were a ton of questions because the whole area of the ADA regulations was changing, and people didn't know how to deal with that. So here we are a year later, and hopefully those who had wellness plan years starting in January of last year sort of got a good feel for how these regulations come into play with their plans. So just to give you a little background on what I'm talking about in case some of you are lost. So in May of 2016, the Equal Employer Opportunity Commission, or the EEOC, released final regulations on employer wellness programs as they relate to the American with Disabilities Act. So a notice of proposed rulemaking was previously issued in April of 2015, and then the effective dates of those rules went into effect in January of the following year. So those plans that start January 1, like to encourage employees to participate. So these final rules really cleared the air for some of that mystery surrounding those previous regulations. What these final rules did was they provided guidance as to what the maximum incentive is that employers may offer employees, and what they can do in terms of asking disability-related questions. So the rule also explains the differences between the ADA's requirements for voluntary health programs and that interplay with the other federal rules like HIPAA, as amended by the Affordable Care Act, and those govern the wellness programs that are part of the group health plan. And don't worry, I'll go more into what each of these things mean, but just wanted to give you a little background on what these final ADA regulations said. The rules also imposed a notice requirement and confidentiality requirements, which I will also talk about. So why are we even talking about the ADA? So wellness programs, again, that include any sort of disability-related inquiry or any sort of biometric or medical examinations, that's when these ADA rules come into play. So anytime you have that as part of your wellness program, you have to think, okay, now I need to put on my ADA compliance hat and make sure that my program here is in compliance with these EEOC final ADA regulations. So again, under these new rules, a program must have these three requirements. So it must be voluntary, and I'll tell you what voluntary means in a minute, meet the confidentiality requirements, and be of reasonable design. So that first requirement, when we're talking about voluntary, what does that mean? So as I previously mentioned, before these final rules came out, the EEOC had not clearly defined what a program, what it means to be voluntary. So now we have a better understanding. So the maximum incentive can exceed the ADA rules. The program cannot be mandatory for employees to participate. And the third one is employees can't be excluded from any of the employer's health plans or benefit programs for non-participation or a failure to achieve the outcome of whatever your wellness program is all about. So what is that maximum reward or incentive? Well, the ADA or the EEOC says that the maximum reward is 30% of the total cost of the employee-only coverage. So, so that means that we're talking about the portion that the employer pays as well as what the employee pays. And this slide is sort of foreshadowing what I'm going to talk about at the end of this presentation, which is the AARP versus the EEOC, because that case is all about that 30% and whether or not that 30% rule is going to stay in place as we go forward. But again, I'll talk about that in the end. But just wanted to give you a heads up, a little asterisk next to that 30% because that could possibly be changing. So when we're looking at the differences between this maximum reward of 30% for the ADA versus HIPAA incentive rules, we have three differences. So with HIPAA, HIPAA rules are going to look at the cost of family coverage when dependents participate in the program. Now, if you look above, again, that 30% under the ADA rules is the total cost of employee-only coverage. Another difference between HIPAA and the ADA, a 50% reward is available for smoking cessation under the HIPAA rules, and for ADA rules, it is only 30%. And then, again, there's no cap for participation-only programs under HIPAA rules. So the final EEOC regulations provided clarification as to how you calculate that 30%. So there are 4 different scenarios, and depending on what you're doing with your wellness programs at your workplaces, it will fall under one of these 4. So the first scenario is when enrollment in a particular health plan is required to participate in the wellness program. So when you're trying to figure out what that 30% calculation is, that limit is going to be 30% of self-only coverage. The second scenario is when you offer one health plan, but enrollment in that plan is not necessarily required. Again, that calculation is going to be the same as in that first scenario. The third scenario is when you offer multiple plans, but you don't require enrollment in a particular plan to participate in the wellness program. So in that case, it's a little different. The limit's going to be 30% of the lowest cost of the self-only medical coverage. And fourth, if the employer offers no health coverage or no health plan, this one's a little trickier. The limit's going to be 30% of the total cost of a 40-year-old non-smoker purchasing self-only coverage under the second lowest cost silver level plan in the location of the employer's principal place of business. Say that fast 5 times. So I think most of the time that fourth one's, I'm guessing for most of you that's not going to come into play. Most of you have health plans, and so you're going to be looking at those first 3 scenarios. But in case there is no health plan and you do have a wellness program, to come up with that 30%, figure out that 30% limit, that's how it's done. So when we're talking about incentive, what is the definition of incentive? What are we talking about here? Going back to the definitions and clarifications the EEOC provided, we have to look at exactly what that means. So we're talking about any reward, discount, or a penalty, whether or not it's monetary or non-monetary. So even de minimis items like a coffee mug or a t-shirt or a meal, you have to put values on everything. So sometimes that can be pretty difficult to assess when we're talking about, let's say you have a wellness program and the reward is a better parking spot in your parking lot at work. I mean, how do you put a value on that? I don't know. I mean, I'm open to ideas, but in terms of that 30%, that 30% limit, you do have to put a monetary value on that to figure out how it comes into play with that total cost of the plan in those different scenarios I just went over. So I mentioned tobacco cessation programs, and as I had said, the HIPAA, or under the HIPAA rules, HIPAA allows for a reward up to 50% of the cost of coverage for those tobacco cessation wellness programs. But the EEOC under the ADA does not allow for this additional reward. So if you're wanting to offer a higher reward to your employees for tobacco cessation, you want to design it in such a way that you're falling under the HIPAA rules rather than the ADA rules. So how do you do that? Well, as I said, when the way the ADA comes into play is if you're asking or requiring a medical exam like a nicotine test, and or asking any sort of disability related questions. Well, the tricky part, or I think the strategic part, I guess we'll call it, is that you could ask if an employee smokes, and you require the smokers to attend a smoking cessation program, but you don't necessarily ask them if they're addicted to nicotine. There's the difference. An addiction is a disability. So if you were to ask, are you addicted to nicotine, then suddenly you're in that ADA realm, and you're going to be at that 30% limit. So again, if you want to just ask, do you smoke? Well, that puts you outside of that ADA realm. And so if you want to reward your employees at a higher limit for not smoking or going through those programs, that's a great way of doing it. So some employers provide more than one health plan to their employees. A basic health plan to all employees, or a more comprehensive plan to employees who participate in wellness programs. So some employers, so the ADA does not allow employers to exclude an employee from a plan based on wellness participation or program. I think I I mentioned that earlier. But the big question is, how many plans do you have, and what is considered a plan? What's one versus what's more than one? So we want to go kind of through this analysis. So the first question is, are there two benefit offerings? Are two benefit offerings different plans? Well, the regulations actually leave much clarification to be desired on this. So even though employers are permitted to combine plans for Form 5500 or other ERISA compliance purposes, the ADA actually doesn't address whether or not you would combine these benefit offerings as different plans. So in terms of well, it's unfortunate that the ADA rules don't address this, but we could surmise that because the purpose of the EEOC's rules is to avoid excluding employees from benefit offerings when they choose not to participate in wellness programs, then I would say that the safe approach would be to offer all plans to all employees working sufficient hours, but charge employees who don't participate more. That's kind of the safe way of doing it in case you're just not sure whether you should be combining these things or considering them different plans. So going back to those three requirements, that first one is voluntary, as we just talked about. The second one is meeting those ADA confidentiality requirements. So, notice is distributed to employees before employee provides health information. So the notice is going to have to describe the information being collected, how it's going to be used, who's going to receive it, and how will it be held confidentially, or how it will be kept confidential. The employer only gets aggregated information, so this means that there is no disclosure of employee names beyond what is necessary to administer a health plan here. The employer may not require, as part of the confidentiality, employer may not require employees to agree to the sale, exchange, sharing, transfer, or other disclosure of the medical information. And then another one of these requirements is that the employer may not require the employee to waive confidentiality protections under the ADA as a condition for participating in the wellness program. So that's what it means when we're talking about the confidentiality requirements. This is all part of those final ADA regulations that came out last year. So that third requirement is be a reasonable design. And this is one of those squishy ones where you're kind of like, what does that even mean? Well, a wellness program must be reasonably designed to promote or prevent disease. So that means that a program must have a reasonable chance of promoting health or preventing disease. The program must not be overly burdensome, and the program must not it's not going to try to get around violating the ADA or other employment discrimination laws. So the definition is actually similar to the HIPAA requirement for health-contingent wellness programs, which I'm going to talk about in a few minutes. But this is going to apply to all ADA-covered wellness programs. So examples of designs that work or don't work. So conducting a health risk assessment or a biometric screening for the purpose of alerting employees to health risks would meet that standard. That would be reasonable. An example of something that wouldn't be reasonable would be collecting medical information without providing any follow-up information or advice. I mean, that seems kind of like a no-brainer. You ask for information and then nothing happens, or you don't tell employees what that's being used for. I mean, this one is sort of the common sense of the three. Just make sure that you are promoting health or preventing disease and that there's that follow through. If you're collecting information, make sure that employees know what that information is being used for. So we went over the final ADA regulations from last year, while the EEOC also at the same time came out with final GINA regulations as well. So, in conjunction with those ADA regulations, they issued this final rule that amends the regulations implementing Title II of the Genetic Information Non-Discrimination Act, or GINA, as it relates to employer wellness programs. So this final rule says that employers may provide limited financial or non-monetary incentives in exchange for an employee's spouse providing information about his or her current or past health status as part of a wellness program, whether or not that program is part of a group health plan, which is when HIPAA regulations come into play. So these regulations were really narrow in scope, and the limited purpose was just to address whether or not it's okay to collect spouse information as part of your wellness program. And so what do those final regulations say? Well, it says that voluntary wellness programs can reward or penalize an employee's spouse for providing that information. No information, however, can be requested of anything to do with the employee's children. That's just off limits. Again, that kind of seems common sense, but just in case, don't ask questions about your employee's kids. And then an incentive calculation, that 30% is going to be identical here as it is to the ADA rules. So if you're trying to figure out whether or not GINA comes into play, you're going to ask the following question. So, does my program ask for information about the employee's spouse, the employee's or the employee's spouse's family medical information, or any other sort of, or does it otherwise inquire about genetic information? If the answer is yes to that, then GINA wellness program rules come into play. So the GINA compliance is very similar to what we saw for the ADA compliance. So you have those three questions: is this program voluntary? Does it meet those confidentiality requirements that I already went through? As well as, does the program have reasonable design? And again, we sort of went over those things, so I'm not going to go into detail again. But when you're going through your compliance checklist, if GINA is coming into play, make sure that all of these questions are answered. So bringing it all together. So you have all these bodies of law, and now you're kind of like, all right, what do I do? How do I make sure that my wellness program is up to snuff and completely compliant with all of these crazy rules? Where you're going to look at the terms of your wellness program first to determine if the ADA or GINA apply. So the first question always is, does this program require a medical exam? So, or ask disability-related questions. It's always going to be your first question. And if the question, or if the answer is yes, then here comes the ADA regulations. The second question you should ask is, does this program require employees to answer disability-related questions? I guess I just said that. That's the ADA. And third, does this program provide for a spousal reward or penalty if the spouse submits information? If the answer is yes, then you have GINA. Okay, so we have ADA, we have GINA. So what do we do about HIPAA? So that's the next step. So you need to determine after ADA GINA analysis whether HIPAA and the ACA come into play. So the analysis here is going to hinge on whether the wellness program is a group health plan or if it's a health plan by itself, or whether it's integrated into that group health plan or it's completely by itself. And don't worry, I will go over that, so there will be no question. So when you're asking the question of whether or not there's a standalone or an integrated wellness program, you're going to ask, is this wellness program part of an existing group health plan? In other words, is it being offered as part of your company's major medical plan? If it is, then it's easy and you know that it's a group health plan. However, if it stands alone but provides or pays for health benefits, if you're asking that question, if the answer is yes, then it's a group health plan. So a program must not offer any type of medical benefit or require any medical test. The third question is, does it stand alone by itself and not provide any sort of health benefits? If that's the case, then it's not a group health plan. So I'll give you some examples. So an example of types of standalone wellness programs that are not part of a group health plan would be something like a program that pays for health or weight loss club dues, so gym memberships, award t-shirts to people who walk a certain number of miles, like with a Fitbit, or provide some health information for that. Programs in which an incentive is offered is completely unconnected to the group health plan. So if you just give like a cash bonus for those employees who don't smoke, that's going to be completely separate. And then if you have like a standalone risk, health risk questionnaire or assessment where you're not going to be providing or paying for any health benefits. But anytime, and I know I feel like I'm like a broken record, but anytime you have a physical exam or you're asking disability-related questions or any sort of biometric testing, that's going to make it part of a group health plan, and so that's not going to be one of those standalone situations. So why does this all matter? Why does it matter if you're determining whether or not your wellness program is part of a group health plan or not? Well, if it's part of a group health plan, then you have the whole body of rules under HIPAA that you have to think about, as well as ACA mandates. There is an exception for accepted benefits like limited scope dental and vision, where those won't come into play even if they are part of a group health plan. So in terms of the HIPAA rules, I've been talking about the ADA and GINA, which new rules came out last year, or went into effect last year. For HIPAA, we saw regulations in 2013. So since then, we've had these existing rules under HIPAA. So under these rules from 2013, it increased the permissible reward, or that incentive limit, from 20% to 30%. And as I mentioned before, under HIPAA, there's a 50% limit for tobacco cessation programs. And then under these rules, it kind of subdivides health-contingent wellness programs into two groups: activity-only and outcome-based wellness programs, which I'll go over in a minute. So HIPAA is the key law that governs the way in which employers structure its wellness programs. So generally under HIPAA, I mean, the main message of HIPAA generally is that a plan cannot discriminate among similarly situated individuals based on health status. So among these other things, it means that plans can't charge individuals more, or different premiums or impose different costs based on any presence or absence of a health factor. However, HIPAA affirmatively recognizes that non-discrimination provisions were not means to prevent a group health plan from issuing premium discounts or reduced co-payments in return for programs. Essentially, wellness programs are the exception to your basic HIPAA rules. Or the exception to HIPAA's non-discrimination requirements. But it is important to distinguish that this exception of the non-discrimination requirement in allowing wellness programs, it's only available to group health plans and not for individual market coverage, which is why it's so important to determine whether or not your program is part of a group health plan, because otherwise this exception under HIPAA is not going to exist for your wellness program. Federal regulations provide specific guidance for evaluating the permissibility of wellness programs under HIPAA's non-discrimination requirements, which is what I'm talking about, that came into play in, the most recent in 2013. So, in terms of types of wellness programs under HIPAA, we have these two different categories. So you have your participation-only program. So that means that none of the conditions for obtaining the reward are based on an individual satisfying a standard that is related to a health factor. The second one is the Health-Contingent program. So that's going to require an individual to satisfy a standard related to health factor in order to obtain a reward. Or it requires an individual to undertake more than a similarly situated individual based on a health factor in order to obtain the two rewards. And I know this is, I'll give you an examples in a bit, because I know this probably makes it's just legal jargon, right? Doesn't make any sense. But there are two different types of health contingent programs. So you have your activity only health contingent and then outcome based wellness programs. So participation only programs. So those programs do not condition eligibility for reward upon a participant's ability to meet a health standard. So eligibility rather is based on just participation in the program. So that would be like attending a health fair, doing a test, or joining a health club. Another example would be a program that reimburses employees for the cost of participating, or gives a reward for participating in a smoking cessation program, but it doesn't actually give any sort of regard to whether or not that employee actually quit smoking. The fact that they participated in that smoking cessation program is enough to get the reward. So those are considered participation only programs. So these programs are actually, they're subject to far fewer regulations than standard programs, and are permissible under DOL regulations so long as they're available to all similarly situated individuals. But again, you have to keep in mind those ADA rules that we discussed earlier if you are asking disability-related questions or do medical testing, even if the result of those things don't matter in terms of the reward. Okay, so then our second bucket of wellness programs under HIPAA would be the health contingent programs. So you have activity, and so there's a subsection of these as well. So you have activity-only wellness programs and outcome-based wellness programs. So health contingent programs require an individual to satisfy a standard related to a health factor in order to obtain that reward. So an activity-only health contingent-based program would be walking or dieting, or a diet or an exercise program that is offered to your employees, which some individuals may not be able to participate in or complete. Let's say you have, I don't know, a walking program where somebody gets a reward if they do 10,000 steps a day. Well, if you have an employee who says, well, I can't do 10,000 steps a day because of a medical condition, and there's just no way I can get that reward, that doesn't seem fair. Under that sort of situation, that would be considered an activity only, where it doesn't matter, it doesn't actually, getting the reward is not going to be determined by whether or not the person actually gets there. If they can only do 5,000 steps instead of 10,000 steps, well, they're still going to get the reward. In comparison to that, you have your outcome-based wellness program. So that's going to require an individual to attain or maintain a specific health outcome in order to obtain the reward. So examples of that would be not smoking, or you have a tobacco cessation program and the person actually has to stop smoking to get the reward, or attain certain results on biometric screenings. So for those health contingent programs, either one, the activity only or outcome based, there are yet another list of requirements that have to be met in order to make sure that you are in compliance under HIPAA. And so I will go through those now. So you have 5 requirements. So that first one is the program must give the individual or the employee an opportunity to qualify for the reward at least once a year. So offering it at the start of the plan year is sufficient, and a mid-year offering is not actually required, but that is the first requirement. The second requirement is the reward must not exceed 30% of the cost of coverage. You've seen this before, and I've already mentioned about 5 times, but you do have that 30% limit under HIPAA. So examples of rewards are going to be discounts, rebates on premiums or contributions, a waiver of cost-sharing mechanism, and a value of a benefit not otherwise available under the plan. And again, under HIPAA, under one of these health-contingent programs, you will have that 50% limit for tobacco cessation. The third one is reasonable design. Again, this is the same sort of description or definition that we saw under the ADA regulations for reasonable design. So, you know, it has to provide a reasonable chance of improving the health of or preventing disease. It's not overly burdensome, etc. But again, programs covered by the ADA are subject to these requirements, even if they're participation only. So that's just one of those caveats of when you're looking at your own wellness program and you're going through the compliance list, and you think, oh well, if it's covered under the ADA, but it's participation only, then I don't have to think about these requirements under HIPAA. But this is one of those exceptions where if it's participation only and not health contingent, then you still have to make sure that these requirements are met.
The fourth one is uniform availability. What does this mean? Well, I think I've already mentioned the phrase similarly situated individuals. So what that means under HIPAA is that plans may treat distinct groups of similarly situated individuals differently. You have to make sure that the distinctions between or among the groups are not based on a health factor. So when we're talking about, well, what's considered a health factor under the law, that's going to be things like health status, medical condition, claims experience, receipt of health care, medical history, genetic information. There are quite a few things that will be considered a health factor. So defining whether an employment classification is bona fide is going to be based on relevant facts and circumstances, whether the employer uses the classification for purposes independent of the class or qualification of health coverage. So when we're talking about uniform availability for a health contingent program, we're looking at whether this program meets the general similarly situated standard. So that means that different sort of treatment between these employees is only going to be permissible if it's based on a bona fide employment classification. I know this one is a lot of legalese, but basically it's just that if you have differences between employees, you can only have different sort of subclasses of employees in order to justify those differences, and it can't be based on a health factor. So there are actually different rules for activity only and outcome-based programs for this uniform availability requirement. So under activity only, you have to provide a reasonable alternative, meaning if the person is unable to perform or to reach the goal, that you have to provide a reasonable alternative if it's unreasonably difficult for that employee due to some sort of medical condition to satisfy the applicable standard. So this goes back to my example of a Fitbit, 10,000 steps, they can only do 5,000. Well, if they can only do 5,000 because they have a knee issue, well, you will want to provide some sort of alternative, reasonable alternative so that they can actually achieve what is being sought out under the wellness program. And
Another situation is if it's medically inadvisable to attempt to satisfy the otherwise applicable standard. So if an employee comes to you with a doctor's note saying, my doctor says I can't do this, I want to, is there something else that I can do in order to get the reward of the wellness program? The answer should be yes, and have a reasonable alternative program available to that employee. So for outcome-based programs, when we're looking at uniform availability, you must provide a reasonable alternative if, again, that participant does not meet the specific goal or specified outcome of your wellness program. So that's just something else to keep in mind when you are thinking about this fourth requirement of under HIPAA. So number 5 is the notice of availability of reasonable alternative standard. So the plan or issuer must disclose in all plan materials describing your activity-only wellness program the availability of that reasonable alternative standard to qualify for the reward. So actually in my example, if the employee asks, is there anything else I should do? That should actually already be in writing. So that should already be part of your wellness program. Part of that is to include contact information for obtaining that reasonable alternative standard and a statement that recommendations of an individual's personal physician will be accommodated. If plan materials merely just mention that a program is available, but there's no details as to what that program is, that disclosure is not required. So there's actually sample language in under HIPAA that gives regulations that give some examples of how to describe those reasonable alternatives. So you also, like under the ADA regulations, you also have confidentiality guidelines under HIPAA. So HHS provided additional guidance in 2015 and clarifies that while employers are not covered entities in their capacities as employers under HIPAA, they still do have confidentiality obligations when there is a wellness program covered by HIPAA. So that's just another thing to just keep in mind. So that means that where employers perform no plan administrative or is not a plan administrator, the plan can only disclose employers just certain information. I don't think I said that right. Where employer performs no plan administration, the plan can only disclose the employer certain information. So best practice is always just keeping that personal, that health information out of your hands as much as possible if you don't need it. It's always best practice. Just don't ask for it, don't take it unless you're specifically using it for your wellness program. Just a reminder, just after all of this, being in compliance, again, can be really difficult because you're not always dealing with one body of law. So it is challenging, but we're always here to help if you have questions when it comes to the legalities of it, because I know it can be a little overwhelming, just like all of those slides probably were. So sorry about that. So I want to walk you through what's been going on at the EEOC, and as I mentioned at the start of this, there is an active case that may change the course of wellness program compliance going forward. So want to give you the update on that. So basically, the AARP brought a suit against the EEOC in October of 2016. So this was soon after those final regulations came out from the EEOC on the final ADA regulations. They brought a case in the United States District Court out of the District of Columbia. And in that case, among other things, they alleged that the 30% incentive amount, which we've talked a lot about today, under the ADA and GINA regulations, is, quote, arbitrary, capricious, and abuse of discretion, and contrary to the law. Can't get more dramatic than that, right? Especially when it comes to wellness programs. We don't see that a lot. So that was really exciting. Like, ooh, this is getting juicy. So the AARP brought these allegations, and the court, actually, the district court judge, actually sided with the AARP and found that the EEOC did not provide adequate basis for that 30%. Did seem kind of random. I mean, on the one hand, they were probably going off of those HIPAA regulations where we saw the 30%, but nonetheless, the judge did find that there's no real justification for choosing 30%. But on the other hand, the judge didn't actually vacate those rules. So all those rules we just talked about are still in place. Instead, so the reasoning that the judge gave was he didn't want to cause just craziness in the world of wellness programs if suddenly those rules were vacated, because as you know, as you've probably experienced, after those regulations came out, people were scrambling to make sure that they were in compliance. So the judge figured, okay, if I just say, never mind, these rules aren't in play anymore, that would just cause way too much craziness. So instead, he just said, yeah, you didn't give adequate basis for that 30%, but the rules are still in place for now. So then, in September of 2017, the EEOC told the court, in response to that order from the judge, that they expected to issue a proposed rule addressing the 30% incentive mark by August of 2018, so coming up in 8-9 months, and final rules would be out by October of 2019, but with the expectation that those final rules would not be applicable until 2021. So that's kind of far into the future. So then, in response to the EEOC's response to the court, the ARP then filed a motion in late December, so just 2 months ago, asking the court to modify its earlier judgment. So at that point, the court then ordered the EEOC, if they didn't come up with a new or proposed final regulations, that the current regulations that we know that we've been talking about today would be vacated as of January 1st of next year. So then the EEOC brought its own motion asking the court to reconsider that. The court agreed that they couldn't actually hold the agency to the agency's proposed kind of dates, the dates in that third bullet point. The court said, yeah, I guess I can't actually hold you to having proposed rules out by August of 2018 or having a final rule out till 2019, but the court also said, but as for nullifying the current regulations, I'm still going to do that as of January 1st, 2019, if you don't come up with those new proposed rules. So, what does this all mean? So with this January 1st, 2019 nullification of the rules date looming out there, we could see a few things from the EEOC. One option is we could see the EEOC reissue the same regulations that we just talked about today, but provide more justification or explanation as to how that 30% is voluntary and reasonable. Another thing we could see is the EEOC might allow those regulations to be vacated and just poof, that 30% goes away. Or we could see something completely different happen, like issuing completely new regulations. What we're anticipating. Yeah.
What was AARP's issue with the rule anyway? Why did they struggle with it? I mean, what was the problem?
I'm trying to remember. I don't remember the factual basis behind it.
Wasn't it the definition of the word voluntary or something, or did that have nothing?
Yeah, no, I think it did. I mean, they were questioning, how is 30% voluntary? But I mean, it obviously had to do with their own wellness program. I mean, there was they tied it back to their own program, but I honestly don't remember the specifics.
Or older workers. I mean, AARP would be concerned
Right.
with older workers
Right.
participating in wellness programs. I don't know.
Yeah, no, you're right. And Alexa, you're right. I mean, they were questioning what is that definition of voluntary? How is 30%? How does 30% equal voluntary? Like, how are you making that jump? Like, explain that. But I'm sorry, I don't remember the specifics of the case. But I'm sure it was something very, very juicy. So what we're anticipating is that the EOC new rules, we think that they're going to either allow a lower maximum incentive level, that 30% actually seems pretty high, or the other possibility is it won't actually include a specific number like 30% and will instead have some sort of fact and circumstance test of reasonableness sort of thing, which I actually think could get more confusing, because then it's a case by case sort of situation. At least with a number in mind, you can just do the calculation and know where you are. But it's quite possible that the EEOC could issue regulations that more closely mirror the HIPAA regulations, or suggest that compliance with HIPAA regulations will satisfy the ADA and GINA regulations. But one thing to remember is that the current EEOC regulations don't use concepts from HIPAA regulation or wellness regulations, but there are some differences, as we kind of talked about. So, for example, HIPAA regulations limit the incentive amounts generally to 30% of the cost of coverage in which the employee is enrolled, while the ADA regulations limit incentive amounts generally to 30% of the lowest cost plan. So, for the time being, all of the existing ADA and GINA regulations remain in effect. So, if you get nothing else from this presentation today, just know that just continue to comply with what's already in play now. Just because we don't know what's going to happen, and this is what the law is now, all those regulations and all those requirements are still into play. But at the same time, you may want to start to think about strategies to take if those regulations lapse. If suddenly those regulations are no longer in play, then you will want to figure out how you can design your program to make sure that you're still in compliance with all of the other bodies of law. So I know, I think, Alexa, you said that I think you had mentioned that you're getting questions about, or employers are wondering, should we just abandon our wellness programs with all of the uncertainty? And we're saying no. If you want those wellness programs, definitely keep doing them. Just make sure that you have in the back of your mind that things could change in the next year, or even less than a year. We may get proposed regulations that will kind of steer us in the right direction. So it's important to note, though, that this order, the court order, as part of this case, it only vacates the ADA and the GINA regulations as to the amount of the incentive, so that 30%. All of those other rules, like the notice, the confidentiality requirements, all of those regulations and guidance will still be in play, even if that 30% portion goes away or changes. So just because some things will be changing based on this court order, just keep in mind that it's not as if everything is being abandoned. It's just that one portion of those regulations, that 30%. So if you are thinking about designing a wellness program that's not yet in working order yet, if you're still trying to come up with something, my recommendation would be don't necessarily ask or have disability-related questions or medical exams as part of it, just because we may see that part changing when it comes to the 30% incentive level. So that's just something to keep in mind if you're kind of thinking about creating a wellness program and you haven't yet. A good strategy would be maybe just to avoid that altogether, just so that you don't have to change it later. So that's it. That's all we got.
There might still be coffee left if you guys need to wake up before you drive out of here. But thank you so much for joining us today. We're really, really happy to have you here. And then we'll let you know, I'll send you some information about the slides and all the upcoming information. And thank you again.